Non-binding agreements play a crucial role in modern business negotiations. These documents express intent without creating legal obligations, serving as stepping stones toward formal contracts. A non-binding agreement outlines the parties' intentions to negotiate or collaborate without creating enforceable legal duties. These documents are particularly valuable during preliminary business discussions, allowing parties to explore possibilities before committing to binding terms. Several types of non-binding agreements exist in business practice. Letters of intent outline potential deals and future negotiations. Memoranda of Understanding, or MOUs, typically document potential partnerships or joint ventures. Term sheets summarize key financial and legal points in investment scenarios. Heads of agreement outline basic terms before formal contracting. Letters of comfort provide assurances without assuming legal liability. What distinguishes binding from non-binding contracts? A binding contract requires several essential elements. All parties must understand and agree to the terms. The contract must contain an offer and acceptance. The parties must exchange consideration, which is something of value. Additionally, binding contracts cannot involve fraud, coercion, or illegal activities. The differences between binding and non-binding agreements are significant. Binding agreements are legally enforceable in court, while non-binding ones generally are not. Binding contracts demonstrate clear intention to create legal obligations, whereas non-binding documents merely express interest. Binding agreements often follow formal contract structures, while non-binding ones may be more informal. When binding contracts are breached, parties can seek legal remedies, which is not typically possible with non-binding agreements. Interestingly, non-binding agreements can sometimes become enforceable under specific circumstances. If one party relies on the agreement in good faith and suffers losses, courts may award damages. When parties begin performing terms of the agreement, judges might determine that a binding contract has been implied. Even if labeled non-binding, contradictory language or behavior could override that designation. Courts may also intervene if one party uses the non-binding label deceptively. To draft effective non-binding agreements, follow these best practices. State the non-binding nature clearly at the beginning. Maintain consistent language throughout to avoid contradictions. Identify any binding clauses separately with clear headings. Define the document's purpose as exploratory or preliminary. Include a governing law clause specifying which jurisdiction's laws apply. And always consult legal counsel before finalizing. Sometimes business situations require documents that combine both binding and non-binding provisions. This approach works when parties are ready to commit to certain terms while still negotiating others. When creating such hybrid documents, accuracy and consistency in wording are essential. Clearly distinguish between intentions and obligations. Include conditions that must be met for provisions to become binding. Thoroughly explain the requirements for creating a fully binding agreement. Understanding non-binding agreements is essential for effective business negotiations. These documents allow parties to explore opportunities without immediate legal commitment. While generally unenforceable, certain provisions or circumstances can create legal obligations. By clearly marking agreements as non-binding and consulting legal experts, businesses can protect their interests while building toward formal contracts.